Lawyers of Reddit. What is a detail that your client failed to bring up to you that completely lost you the case? Story 1. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives in my case and this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-a-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Story 2. The company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing. Though we had heard rumblings that the COO was rather hands-on with the work and with the female employees. Apparently, there was a walkaway package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half-dozen different ways, and each time the COO denied any out-of-work contact. Later, we meet with the woman and her lawyer with the COO not present. Her lawyer gave us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause, so no walkaway package. At her request, the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Story 3. Lawyer in the UK. I acted as a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously causing grievously bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in statute or at common law contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. Story 4. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she claimed she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay for this one. I legitimately do that all the time during consults. Give my honest assessment if the case is even worth doing, and so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. Grew up in Canada. It is indeed possible to drive 70 on fresh snow, and pretty easy to maintain control. Only gets dicey if you hit slush or ice. Story 5. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation and no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charged me with assault. I never touched her. I just threw an AC at her. This is bullshit." The judge rescinded plea deal because of defendant's attitude and lack of remorse, went to trial, and got a year in jail. Story 6. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing, it came out that they were never a couple, that he was sending sex toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. Ripper. We lost. He got laughed out of court, and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. Story 7. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him, asking him to not hide shit from me and to be honest, we go into court and at cross-examination, the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then go pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex-brother owns a private investigator firm. Fucking idiot. Story 8. Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, "Can we take a break?" We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. Story 9. Case as a paralegal. Negligence case. The client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Your Honor, if the capable repairman had simply fixed the cable in accordance with professional standard practices, my client would have had no other recourse but to keep his ostrich in the corral on the evening in question. Story 10. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. Story 11. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that my parents are stable, working lawfully, have a suitable apartment, don't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pre-trial to try and convince guardians. I met with my client before the hearing to see if anything changed. Nope, all good, let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1, that no longer is working, 2, no longer in the apartment. 3, doesn't want to have a relationship with guardians despite her kids loving them. 4, won't send her kids pictures of the toys they miss and can't have. 5, plans on moving out of state. 6, thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Just to clarify, client was working really hard to get everything right and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell, as I did my due diligence to make sure things were on the up and up and statutory requirements were met. Things feel very fast, apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. I really want to read those 15 seconds of the court transcript. That's an impressive amount of self-fucking to cover in such a short amount of time. Story 12. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. Story 13. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior, the couple decided to get back together. And instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people, and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that getting back together was a detail any of their attorneys needed to know. And yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. Hey, at least a happy ending for the couples. Story 14. I'm a public defender in an area with lots of meth use. Meth makes most people talk. A lot. So I can't tell you how many clients forgot to mention that they got to jail still high and called their mom/girlfriend/buddy on the recorded jail phone and not only confessed to the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. I'm getting this question a lot, so I'll add some info here. This is not legal advice. Just explaining things a bit more. Calls to a lawyer are privileged and generally go through dedicated lines that aren't recorded, depending on the facility. Calls to family, friends, etc. through the normal phones are not privileged, are generally recorded, and can be used in court. There are usually printed signs near the phones and a recorded warning before each call that this is the case. Story 15. I heard of a guy trying to appeal his disability benefit being revoked. He was supposedly a paraplegic, but the opposite had over 10 minutes of video footage of him walking, running, and even jumping over a fence. After the 1-minute mark, the judge said, "Okay, I've seen enough. Please leave." Story 16. Credit card theft and fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how she could be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, "Because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him." The jury convicted him, and I learned that day to better prepare my clients for trial. Story 17. There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the back seat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question. Was there anyone else in the back seat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have possibly been in the back seat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and, shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact, no matter how obvious it may seem. Story 18. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with a pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus, it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along the lines of, "Thrown, huh?" And the defense lawyer said that due to technical difficulties, he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. Story 19. It's not even my stories, but my dad's. He was working as a fraud investigator for an insurance company. I have a few stories of his, but there's two of them. Guy was claiming theft of multiple items, but mainly a ring. Things weren't adding up, so my dad and the insurance company's lawyer decided to do a depot of him. Guy shows up and is doing the depot when my dad notices the guy is wearing the exact ring he's claiming was stolen. My dad slides a note to the lawyer telling him the guy's wearing the ring. Once the note got slid, the guy realized what happened and put his hands under the table and took the ring off. They asked him to stand up, and lo and behold, the ring fell to the ground. Another one is a guy claiming a break-in and theft. Immediately, things weren't adding up, as the window was broken out instead of in. The guy submitted Polaroids of items he claimed were his, like TVs and such. In the Polaroids, you could see the reflection of the store they were in on the glass. He also claimed numerous CDs and records, but oddly enough, every single one started with an R, S, or a T. We're talking hundreds of CDs and records. My dad was about to deny the claim in person, but noticed he had a gun on the table, so decided to do it over the phone. Ready for an escalation? Later, this same guy was arrested for beheading a prostitute and throwing her head in the river. Story 20. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pin rolled off the table and she was bending over to try to reach it from her chair, but the pin was too far away. So she stood up and bent over and picked it up and went back to her seat as if nothing was out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay and her response was that she was fine. Her attorney leaned over and said something to her, and she then loudly started complaining about her back and how much her back hurt, but no one believed her.